I'm going to go ahead and call us to order. We're a few minutes late, but I think we have a quorum with a little wiggle room. So Director Apollo, if you would go ahead and call the roll.
Thank you, Madam Chairman. Do we have Commissioner Pope?
Here.
Commissioner Wallace?
Here.
Commissioner Reville?
Here.
Commissioner Meyer?
Here.
Chairman Gordon?
I'm here.
And Madam Chairman, I will acknowledge that Commissioner Naves is traveling internationally. And Madam Chairman,
Here.
you have a quorum.
And just so everybody's aware, I think my understanding is I'll be chairing the meeting, but Governor, please jump in or elbow in or whatever if I do something wrong or say something wrong or skip anything. So with that, I think we have a fairly robust agenda. I don't have any particular comments to make, so we can go ahead and move on to review and approvals.
Absolutely. Thank you, Madam Chairman. Quickly, I'll do a few quick confirmations with our tech resource. So I'm just going to confirm that we are live and out of the practice room. We have the recording running, transcription and closed captions running, and everyone who's in panelist has their panelist links open. Thank you, sir. And then I will quickly read a few announcements and disclaimers. So as always, agendas and sign-in sheets are in the back of the room. If you wouldn't mind filling those out if you are here in person, we certainly appreciate it. And for my disclaimer, key decisions pertaining to the Wyoming Stable Token Initiative will be made by the commissioners of the Stable Token Commission or the state legislature in public meetings such as this. At this time, no blockchain has been selected for deployment of Wyoming stable tokens, and no Wyoming stable tokens have been issued. Further, the only commissioners are those appointed by statute, the governor, or a majority vote of the commission. Information outside of these public meetings should only be considered factual and legitimate if it is distributed through our official channels. At this time, these are limited to our website at stabletoken.wyo.gov, the Wyoming legislature website at wyoleg.gov, and our social media channels with the @WyoStable username on Twitter, YouTube, GitHub, and Warpcast. So with that said, I'm happy, Madam Chairman, to get into the reviews and approvals.
Proceed.
Thank you, Madam Chairman. So we'll start off with today's agenda. We'll review the meeting minutes for our meeting from April 18th, that was STC-13, and our meeting from May 23rd, which is STC-14. We'll do the monthly budget review, and we'll add some context there regarding the biennial year end and the transition to the next biennial fiscal year. I will share a little bit more about the contact list that I provide monthly and a brief update on where we are with getting the subcommittee stood up. We'll do our brief stable token industry update, and then we'll segue into recruitment. We'll recover off on the position of the 4 jobs that we've listed so far and the traction we've got. We'll talk about some of the way the applications are coming in, and then we'll spend some time working through the draft hiring policy. This one came together a little bit closer to the pin, so we'll take the time to go through that piece by piece. After that, we will discuss the procurement rulemaking, which we had talked about in the last few monthly discussions that we've had. We have draft procurement rules ready, and we will look to get an approval on that so we can begin the rulemaking process formally. Then we'll talk a couple of next steps that will unlock for us, followed by public comment, and I'll let you know where we're off to next with our upcoming meetings and events. That is your agenda for today, Madam Chairman.
Okay. And Director, remind me, do we normally take a formal vote to approve the agenda?
Madam Chairman, that has not happened at a plurality of our meetings, but it has happened in the last 2 of our meetings. So perhaps we want to continue the trend.
All right.
So moved.
Okay, moved by Commissioner Pope, seconded by the treasurer. Any discussion, additions, changes? Commissioner Gordon? did you
No,
have
I
any-
just was gonna say aye when it came time. I
Okay.
hit it too fast.
All those in favor say aye.
Aye.
Opposed? Okay, agenda is approved.
Thank you, Madam Chairman. We will keep on moving ahead here. So the next item on the agenda is the meeting minutes from April 18th, which was STC 13. I am happy to provide a 10,000-foot view of these if you'd like to review them quickly, because these are from 2 months ago. We did not have these in the last discussion, so I'm happy to kind of refresh what these are before we approve them and put them into our records.
Director, since we've all had these provided in advance, is there any changes, corrections? Has everyone had a chance to review these?
Madam Chairman? Looking over there, when I made a comment about the LGPSA's treatment of logarithmic stablecoins, could we insert what that acronym says so people know what it actually stands for?
So Director, that's from April 18th. We are looking on page 3, last paragraph.
Madam Chairman,
Is that
if I may?
the place? Sure.
We do have the LGPSA defined about halfway through the page. It'd be the fourth paragraph.
Right.
The Lummis Gillibrand Payment Stablecoin Act.
Oh, here it is. Yeah, Loomis Gillibrand Payment Stablecoin Act. Okay. All right. All right. Good. I'll underline that so I know what the LGPSA is. Thank you.
Any other
very good.
comments or changes?
No.
I would entertain a motion to approve one at a time or both, if that's the desire.
Madam Chair, I move both.
Second.
Moved by the governor, seconded by Commissioner Pope. Any discussion? All those in favor say aye.
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 Opposed? Okay, motion carries. Monthly budget review.
Thank you, Madam Chairman. So moving into our monthly budget review, I don't think there'll be anything eyebrow raising here. As usual, the main mover of our monthly expenses is salaries and benefits, and that's been consistent for the last 4 months, so no notes there. I'll note that for travel, you'll see in May, we did not have any expenses hit for out-of-state travel, either from the team or from the commissioners. I'll note that we are going to have expenses for May captured in June when we get the June 30th budget summary. That would be about $1,800 together between my travel to DC for the Blockchain Summit meeting with the congressional delegation there, as well as Commissioner Novice's travel to Cheyenne for the May meeting and some other work that we did. I'll also note quickly that we do have a software license charge about midway through the sheet here. That's for Adobe Acrobat. That's a one-time fee. So that is now set. And I think everything else is a fairly standard recurring charge at this point. So I will quickly wrap here by noting, as we typically do, that we are coming in under budget for at least the BFY 23 biennium. We are expected to spend $233,000 by the end of this month. And that is, less than 50% of our $500,000 initial allocation that we got in the budget. So if you would like more details about any of these expenses, again, you do have the detailed spreadsheet attached. But typically we just look at the summary here. So happy to answer any questions that you may have.
I'm just wondering, Madam Chairman, is there any attorney fees contemplated or things that they can work on? Because that 80,000 budget is basically going to get rolled into the next biennium's budget or the next yearly budget. So I didn't know, that work can survive the July 1st date. Yeah.
Through the chair, Commissioner Meyer, great question. So the contract we have with our outside consultant for legal advisement, that contract does end on June 30th. So we are working with them to hand over and deliver materials formally that we had been looking at and drafting in the background along the way here. We are looking for a formal delivery of those documents before that date. So as you see here, attorney services, that 80,000, we took that all up front when we engaged Paul Hastings, and there hasn't been anything in that bucket since. And then if we need assistance going forward, it'll be it'll be broader than the remit that we brought them on for the first time anyway. The work we did early on was very much focused on the determination of whether a Wyoming stable token may or may not be viewed as a security token by any of the regulators. And of course, we can kind of add a little bit more flavor and color around that. But if we're looking for a broader swath of support, that would be a new contract.
Okay, all right, thank you.
Madam Chair. Director, on the legal services, was that a retainer that we are anticipated to only use part of and carry a credit into the next biennium, or was that a single one-time upfront payment? And if it was a retainer, about how much have we used?
To the chair, Commissioner Pope, I have an easy answer for you, which is a one-time upfront payment. So no retainers to worry about or calculate.
A question I've got is we got average expenditures here of a little under 9,000 on that line. And so we get 9,000 of service and 71,000 of thank you money?
Through the chair, Commissioner Meyer, I'm not sure if I understood the question or
I'm
comment.
just wondering if it's a one-time payment and they only provided actually $9,000 worth of services, and that doesn't carry forward, do we at the end of this June or July 1 write them a check for 71,000?
Through the chair, Commissioner Meyer, no, this is an upfront payment. So that average expense column is just the average of all of the months.
Just the average of
right?
all of it.
So all this to say is for the 10 months we're going to be operational, our average monthly expense for attorney services will be under $9,000. If I'm understanding the question correctly.
Yeah, well, I'm just curious what work product we're going to get that's actually going to be, delivered on July 1, and if that's going to be, I guess I'm curious whether we made a good deal or maybe we, or just how that's going to shake out.
My understanding, and I'll let Anthony jump in as well, that's just a budgetary calculation for management, but I believe they've performed all the work under that contract. Is that accurate? That was the,
Okay.
yeah.
All
Yeah,
right.
through the chair, Commissioner Meyer, that's correct. The work has been performed. It is a robust document. The commissioners have seen it, an early version of it when we were kind of greatly accelerating towards a potential 12/31 test launch, and we were getting aligned for that. So a lot of the work was done up front in a very truncated span of time, including their support of the report that we delivered to the state legislature on November 1st, I believe. And then, of course, as questions have come up along the way, we've been able to engage them.
Okay, well, we'll I guess, see what they've provided at the end of the year and go from there. Thank you.
Madam Chair.
Just one moment, I see Governor has his hand raised.
Yes, thank you, Madam Chair. Just a quick question for Anthony. I know that when you went through it, you talked about the Adobe subscription. Just a quick question. Is that through the enterprise license, or have you worked with that, or is that a standalone license?
Through the chair, Commissioner, that is I did work with Enterprise Technology Services to get that. So I believe it's a one-time fee. If it is, I could double check. It might be recurring on an annual basis, similar to how Microsoft Office is set up. But I do know, I will confirm that.
Commissioner Pope?
Thank you, Madam Chair. Under accounting rules, if that contract, the legal contract, were to cross the biennium, we would be required to amortize it out and essentially on a monthly basis. And that 88, 88, 89, I believe that's what that represents, is what the monthly cost allocation would be under an amortized system. So since it's not crossing the biennium, I think that number is, is really just an average.
Any other questions, concerns with the monthly budget summary? And then, Director, any comments about the new 2025 budget coming up? If my memory serves me correctly, we get X amount, and the amount we spent this biennium, I don't want to say it doesn't matter, because it does, but essentially we are refilled to the same amount regardless of how much we spent this biennium.
Madam Chairman, that's correct. So one quick note on the budget fiscal year 23 closeout is that I've been working with the A&I team to make sure that we're squared away with any of the documentation or support we need to give them from the agency side so they can close the books for 6:30, and I'm sure you'll appreciate that as well.
I do.
So to be very specific, we don't have any reimbursements outstanding that needed to be handled by 6:30. All of our expenses were handled earlier in the month before their deadlines. And then I think we had one SaaS service that was past the June 10th deadline for reporting. So I worked with the A&I team to make sure that was encumbered appropriately. I've been monitoring expenses since to make sure nothing hits the P card between now and then. So we're all set on that front. I've also, in your packages, included, I found this on my desktop, so gave you all a copy of what the fiscal year dates are in case anyone gets a little lost, because those can be a little confusing from time to time. So you got your cheat sheet now. And then segueing into the budget fiscal year 2025 side of things. Madam Chairman, you are correct in terms of the general overview of how our funds would be received. So per the budget bill, we are not receiving, just a check from the general fund. It is considered other funds, and the amount will be $5.8 million that we're receiving as of functionally July 1st. And I'll put an asterisk on that and come back to it. So the 5.8 million will be less the money we have remaining from the BFY 23 year, which again will be about $267,000. And then I will let you in your office work your magic to make sure that gets topped up. But that being said, I do also want to specify, and because I am still learning a little bit about this process, I am not expecting those dollars to magically show up on July 1st. My understanding is I would be receiving the June 30th budget summary sometime the first week of July. And then once I approve that and confirm that we have a solid number that we actually was our 630 balance, then we can do the adjustments to put the rest of the money in other funds, and then that comes to our operational account.
Any other questions, concerns about the upcoming budget turnover? Right, moving on.
Thank you, Madam Chairman. So I think the next thing that you have in your packages is the contact list. Again, not much to say from my side on this specifically. This is, again, the list of people that I've spoken to essentially since we launched the first RFI. So you can peruse this at your leisure. But if you were to turn to the last page of the document in front of you or the last page of the PDF, you'll see the counter for how many discussions we've had to date. So in total, I've essentially been in contact with about 530 plus people about this project, met with 358 of them, and then that represents about 250 different unique organizations. So again, as I said last month, and I'll reiterate now, this is not me reaching out proactively at this point. This is functionally inbound of people who now know about who we are and what it is we're doing and are very interested in working with us or collaborating in some way, shape, or form. So that's for your reference, but happy to entertain any questions that you may have on it.
Any questions regarding the updated contact list?
Madam Chairman,
Treasurer.
just a little bit of question. It's just, how are you kind of, what's your internal matrix to give you an idea whether you want to call these people back, or are you doing any kind of off-the-cuff ranking of them, or how's that working?
So through the chair, Commissioner Meyer, great question. From our perspective, just with the way that this technology, if we're talking about tech providers specifically, the space is moving so fast. If someone tells me they've got something new or they're working on X, Y, and Z, I'm gonna do my best to learn about it and just understand what it is that's being built, because we'll get to our news update in a second, but there is still large swaths of transformative technology being built and released on almost a monthly basis at this point. So that doesn't mean that there's a ranking in my brain. That just means that I'm staying open and abreast of everything going on. What I will say is when we talk about procurement in a little bit,
Yeah.
that's going to, if we get through the procurement rulemaking today and go down that path, that will open up the pre-qualifications for us, hopefully ahead of our July meeting. And then that's where we can start putting together frameworks for, you can design kind of a high-level RFP. We know what we need, and then work backwards to pre-qualification. That we want to work with partners or a consortium of partners that has accomplished this much to date in their work.
Yeah.
And that'll kind of, I think, create a bit of a preference cascade for us with what is, what's available.
Okay, thank you.
There's no other comments regarding the contact list. Next up is subcommittees.
Thank you, Madam Chairman. This will be a quick one. So I've had an opportunity to speak with a few of the commissioners regarding the subcommittees and the work that we've got set up in Notion at this point. Again, if that's something that I haven't had a chance to speak with you about, we should get some time on the calendar to make sure that we can have those discussions, because we've got it to a point now where we have the working groups represented in, it's called Notion Team Space. It's just a place where we could delegate specific access to the 3 commissioners that are tagged to every vertical or working group. That way we don't have any kind of issues with quorum or public meetings or sequential meetings, and we've kind of got it all gated appropriately there. We've got lists of subject matter advisors who are involved, and I'm onboarding them now through the Code of Conduct. We've got deliverables that are being spec'd out for each of those. So if we haven't had a chance to speak about that and review Notion together, let me know and we'll try to find some time. If not next week because of the holiday, the week after, we can hop on and do that.
And just to be clear, as subcommittee members, is there any responsibility we need to be taking now in setting up meetings, or that will come from you first and then we can activate?
Madam Chairman, that would come through me first. One of the very astute questions you asked at our last meeting was, what is the recurring frequency of a given working group's meetings? And it's going to vary by the responsibilities of each respective working group. So example that you gave and talked about was, working on some of these audit issues or things like working on a component unit definition with MHP. That'll be a fairly quantized set of discussions versus perhaps exploratory work around which blockchain we're going to launch on, or token design, where there's many moving parts, again, many new technical features being developed and rolled out on a monthly basis, and that'll be a different cadence.
Okay, thank you. All right, please proceed.
Thank you, Madam Chairman. So the next one is the stable token industry update. I'll keep this one a little bit quicker than usual, I think. So the size of the industry continues to grow. Versus last month, the aggregate stable token market cap has increased from 157 billion to 160 billion and change. So it's about a 2% increase since we spoke last month. In terms of some news on the domestic side, one of the pieces of legislation that I'd mentioned last month, which was Staff Accounting Bulletin 121, known as SAB 121, that is the legislation that the SEC had passed that was preventing and precluding banks really from custodying digital assets because it made it financially onerous for them. Both the House and the Senate voted to repeal that bulletin, and then that was vetoed by the Biden administration. So the repeal has been vetoed, the guidance stands. It's a little confusing, but that's where that is at the moment. I'll also mention that, speaking of the SEC, we had talked about a case in the past, the SEC versus Debtbox, which is a blockchain company. And SEC had claimed that Debtbox was essentially raising capital in the US and then offshoring it. Turns out the SEC had fabricated some of the evidence that was used to go after this company, and as a result, people had to be let go. The SEC was actually sanctioned, and that they've shuttered their Utah office as a result of that. So as crypto becomes more of a, as we have seen domestically, more of a policy issue, I think we might hear more things along those lines as we move forward. So one more piece of news on the domestic side, Robinhood, which is a payment platform typically known for buying the ability to buy shares through your mobile application. They are buying a blockchain exchange known as Bitstamp. So they will have some of the functionality there as well that we've seen in other domestic exchanges. So that is a couple things I wanted to highlight. In terms of international news, we now know that the Bank of Israel is working on their central bank digital currency, a digital shekel. They are modeling it after what the Bank for International Settlements does, which is creating a kind of a test sandbox and then inviting people to kind of build in there and see what sticks. And then one more thing about the international news is the European Union's framework known as MiCA, the Markets and Crypto Assets Regulatory Framework, that goes live on June 30th. So we'll see how companies start working within that regime. We've already seen a couple of organizations that have shut down rather than comply with it. So it's something that we'll be keeping an eye on pretty closely. It's also interesting because although MiCA is the framework for the entire EU, there still is bandwidth for different countries to have carve-outs. So it's not as unified as it's kind of made to sound. And it'll be interesting to see how that all shakes out as well.
Question on that is that the EU is continually putting these ESG standards and qualifications on everything. Are they moving the same thing in the regulations in Bitcoin and digital transactions?
I would, through the chair, Commissioner Meyer, I would say that with the MiCA framework, I would say the EU has probably outpaced the regulatory framework in the US in the discussions here, which I think is different than how it typically goes. If you look at what's happening in Europe around regulation of artificial intelligence, for example, my own personal opinion is it's been a little bit more closed off to innovation that we're seeing here in the States, whether right or wrong. And that is somewhat of can be seen as a recurring theme, but I think they've led here in the US. They have not.
The other issue that I'm concerned about is taxation. If anything goes into Europe and it's perceived there's money made off of it, especially if it gets into France. So we've had, a considerable amount of problems whenever we dealt with the French as far as taxation. There is an international, agreement on no double taxation, but it's limited to like a 5% rebate to people. So kind of keep your eye open on that, and we'll try to update you on what we've got. We've got some attorneys in France been working on a case for over 4 years, I think now. So there's just some things that we may want to have I think guidance that to stay out of that country as much as we can, because it could just end up with some kind of a problem.
Through the chair, Commissioner Meyer, just a quick response, because I'm certainly not an expert on French tax law. What I will say is it'll be interesting to see if what we're building with the Wyoming stable token as an instrumentality, as a state issuing the instrument, kind of puts us outside the remit of some of that jurisdiction, which typically applies to private companies, but I don't have all the context, so I'm happy to take that up.
What they're saying is that they're asserting the French are, is that no double taxation law applies to only the United States, and none of the states within the United States are actually considered sovereigns. So that's, yeah.
Well, then, through the chair, Commissioner Meyer, I would certainly appreciate you keeping me posted on that.
Thanks, Treasurer. Any other questions on
Madam Chair.
industry update? Commissioner?
About the middle of the month, Tether announced the launch of Alloy, which is a quote-unquote stable token backed by gold. And I'm wondering what your thoughts are on how that affects the industry.
Through the chair, Commissioner Pope, if I do recall correctly, it's referred to as a synthetic dollar. Would that be correct? Is that what you're? I know that there are certain instruments, much like the Athena offering, which you talked about before, which is a very high yield-bearing token. They've been referred to as synthetic dollars rather than stable tokens. So,
Madam Chair. It's described as a novel category of digital assets known as tethered assets, designed to track the price of reference assets through stabilization strategies like over-collateralization with liquid assets and secondary market liquidity pools.
Understood through the chair. I guess what I'll go as far as to say is, I think this is generally speaking representative of a trend in which real world assets are going to start moving on chain. We're seeing more and more of that with work that BlackRock and others are doing. And I think this is one example of that. Now, if I was going to buy tokenized gold, there are other companies. Paxos has a domestic offering in Pax Gold that you can buy a tokenized brick of gold. And if you want to redeem it, they'll send it to you. So, there's different flavors for all this, and I don't have any particular opinion on any of it, other than to say it is a section of the industry that I would expect to grow pretty rapidly once a couple of incumbents figure out the right combination, or hopefully a startup as well can get in the mix there. And then I will, through the chair, quickly add just a couple other pieces of feedback around incumbent offerings. Tether was one of those. One is that PayPal and their stable token has now launched on the Solana blockchain network, and they've enacted or enabled a feature called confidential transfers, which is a technology known as zero knowledge proofs to obfuscate the actual amount of value being transacted back and forth. And I think if that was to take off, that would be one of the first kind of retail utilizations of zero knowledge technology. So going back to your question, Commissioner Meyer, this is where things are still accelerating, growing on a fairly consistent basis around where these enhancements are coming. And then speaking of PayPal, that offering has been put out by Paxos International, which is based out of the UAE. They've launched a yield-bearing stablecoin known as Lyft Dollar, but as we've talked about in the past for some of these offshore offerings, is not available in the United States. There are no yield-bearing stable tokens in the United States to date. So that's the news update. Is there any questions on any of that?
Commissioner Wallace?
Yeah, Madam Chair. Is there any way, you talk about the size of the market, 160 billion. Is there any data as far as what types of transactions those are? I mean, it seems like it's growing leaps and bounds, but I still don't see anything. So is this all institutional trading through digital assets, or do you see any more traditional finance starting to use this rail for stable tokens?
Through the chair, great question. So it's a little bit of both. So one of the reports that came out, well, let me kind of break this down. So one of the charts we have in our business plan from some months ago was a chart showing stable token utilization approaching, let's say, the Visa network. And then in a recent update, we talked about the aggregate transfer volume of 3 stable tokens, so Tether, Circle, and DAI, which is kind of an algorithmic type of stable token. They surpassed the monthly average transaction volume of the Visa network. So Visa has now come out and taken a look at all this data and said, well, it's not really one-to-one. Realistically, if you're looking at Visa's volume, that's retail transactions when I go down to the Paramount and swipe my credit card. If you're looking at stable tokens as a percentage of that, it's a low double-digit percentage. The rest of all that stable token utilization is coming from automated trading in the decentralized finance kind of space, or through now institutional sellers coming in, like the BlackRock Buildle Fund that we talked about in the past. So those are now kind of some of the new market entrants that are boosting those numbers as well.
Madam Chair, do they share any of that data as far as what the retail utilization of stable tokens are?
Sorry, through the chair, Commissioner Ross, I do believe we actually have it linked in our website. If you go to the news and reports section, you might need to scroll to the bottom, or if you're in the section for today's meeting, it'll say show research or what have you. But for April 2024 in reports, it says Visa making sense of stable coins. You can go there and see all this data and how they break it down.
Any other questions regarding the industry update? Okay, let's move on to recruitment.
Thank you, Madam Chairman. I've also been informed a moment ago that the governor is correct. The Adobe license is recurring on an annual basis. So we'll make sure that's in the budget when we start bringing others on and keep scaling. So moving on to the recruitment side of things, I'll quickly just recap where we are with the positions that we approved in the last meeting, and then we'll go into spending a bit of time on the hiring policy. Because again, this is kind of fresh off the presses, and I want to make sure we go through this in detail and everyone has the chance to give feedback. So in terms of where we are for recruiting, the senior business project manager role was listed on June 7th on the NeoGov website through that ANI and HRD manage. That has received 1,132 views. We've got 8 applicants and 2 more in the mix. The CFO role was listed on June 10th. That has 1,022 views on the recruiting site and 12 applicants. We listed the Chief Risk and Compliance Officer on the 24th. That has 748 views and 17 applicants. And then the Chief Information Security Officer went live on the 25th, and we already have 8 applicants for that role. So all in all, we're about, I think that's about 50 applicants amongst the 4 different buckets there. Now, some of them are, I've looked at some of the applications, not all of them are applicable, which is why I want to work through the hiring policy with the commissioners to make sure that we can start triaging the applications we have in front of us. But before we do that, I will quickly say that there are some great candidates in the pool. I think you'll have a chance to speak with them along the way, but just based on the different roles that we are looking to onboard, there are certainly people in the mix that I believe can perform the jobs quite well. So I'll pause for any questions on that, but if not, if there are none, then I will segue into our hiring policy.
Thank you, Director, and you refresh our memory. There should be a fresh, we want to make sure we're looking at the freshest version of that. Is the printed
Yes.
version the freshest version as well?
Yes.
Great, thank you.
So if you are in the room, you've got this paper clipped stacked together. This is the cover sheet for hiring policy and then the actual hiring policy itself. If you are online, I believe it is going to be, I'll tell you in just a second here. Maybe I won't. If you are online, it'd be 15.6.c.Romanet 1 and Romanet 2. So it's the hiring files. So to dive right into it, what I've done here is put together a cover sheet with some context and then the actual policy itself. So the suggested action here is to approve the hiring policy and then deploy the procedures therein for the potential recruitment of these 4 roles that we've discussed. We do have the authority to do this, and if this was not the case, we need to take some more time to refine this, then we can do so, but it might just take more time to appropriately triage and begin interviewing qualified candidates. So for background, the Stable Token Commission does have the statutory authority to onboard resources as it sees fit. That's Wyoming Statute 40-31-105, Romanet 7. We are able to employ director employees as it deems necessary for the performance of its duties, it being the commission. The commission shall prescribe the powers and duties and fix the compensation of the director and employees. So we're able to bring people on and we're able to deputize the director to accomplish that. That being said, we don't have a policy or procedure in place yet. And I wanted to make sure that before we start screening applicants, that we put a procedure in place so that we are all aligned on how this process will go, how interviewing will go, and then how the selection process will go. And then, so just for analysis, this is drafted by me. Again, we do have a bit of a flat structure as a solitary agency resource, and the commission, we do need to kind of figure out some ways to make sure we could put some checks and balances in place. I think we've done that. And then that would manifest through an evaluation committee. And there's also in the policy a option for the commission, should it decide to, it can do resource selection itself through an executive session or special meeting, or it could defer to the director to accomplish that. And then I've got recommended motions on the back of that sheet to approve the hiring rules, and then to authorize the executive director to complete any forms on behalf of the commission that may need to be done for any of the corresponding agencies that help with onboarding. So HRD, A&I, ETS, and so forth. So that's the general overview of the hiring policy before we dive into it. Any questions?
Madam Chairman, I've got a couple of concerns that we had in our office and some proposed amendments there to address, and I think it makes the hiring policy more workable. And could I have time to go over those? I passed them out and I sent them by email and text message to the governor. But
Thank you, Commissioner Meyer.
sorry, Joel, I didn't get any to you, but they're really easy to understand.
I'm thinking, Commissioner, no, I appreciate that, and I appreciate your work on that. I think let's have Anthony go through it and sort of give the overview, and then maybe I'll have you go through your proposed changes.
Yeah.
Great.
Yeah, Madam Chairman, that's fine, and really, I guess we're going to be consistent with the parliamentary rules. We probably need a motion on it, then it'd be on the table and ready to amend after we get the presentation,
The overview.
Madam Chairman.
And one comment, and Anthony, I think I'm stating the obvious, but let me say this out loud and I can be corrected. We don't have to have a hiring policy. We are not required to. However, it appears that it would make sense, given that that we have this job that needs to be done. You have 7 bosses. We need to have some structure, some organized structure that maybe guides this process and filters it through either a smaller committee and then come to a full committee. Again, especially where we're mixing government folks, private industry folks, et cetera, who are not necessarily used to the state processes that we have to go through. So is that sort of, put very roughly, is that sort of the intent behind having this? That is not going to be a rule, it's just going to be a policy. It does not have to go through rulemaking. Is that all accurate?
Madam Chairman, that is entirely accurate, and I'd also add it's so bizarre to have all 7 of the best bosses I've ever had on one team. Anyway,
Great, okay.
thought that would land a little bit better. I digress.
We
So
are all
that-
very smart and kind and good-looking, but we may not all agree on everything all the time,
And that's-
despite all of those things.
That's quite okay, Madam Chairman. I think your point is well taken, and that's the correct characterization for this. What I will just simply add to your note is we do expect a fair amount of scrutiny on the work that we're doing, right? We are going to be under a lens that I don't think many others will be. And as a result, it's going to be important for us to put policies and procedures in place and then follow them. Even if it's not technically, creation of a rule set, we're going to be held to a certain standard. And if people, feel that they deserved an opportunity that we're not going to give them and they push back on it, I'd rather have something to point to about the processes that we went through to get to where we got to, rather than not much of anything at all. And then we might have to answer more difficult questions.
No, that's great. And then one final comment, where this is a policy for the commission, I understand our goal is to potentially get this passed today, but some comfort, and again, correct me if I'm misstating this, if we get something wrong, this can be changed, this can be tweaked in the future very easily with a vote by the commission. It does not have to go through. This is our somewhat of an internal policy. We do not have to go through waiting periods or public comment periods with a policy versus rules.
Madam Chairman, that is my understanding as
Great.
well, that this would be much more easily adjustable. That being said, I will quickly perhaps throw a glance over to Mr. Kenny. One thing that I'm aware of for rules, again, not for policies, but for rules, is that if you do your emergency rulemaking and then try to switch it up while you're, like, let's say emergency rulemaking for procurement, and then you try to change your procurement policy in the middle of an ongoing process, that might be a little bit complicated. I do not know off the top of my head if that would apply to policies and procedures, but I would assume no, because they are intended to be more flexible.
Thank you. Okay, please proceed.
Thank you, Madam Chairman. So digging into the hiring policy that you have in front of you. So again, we just start off with our statutory authority that we just mentioned a moment ago. And then we talk about some of the things we need to accomplish. We need to hire employees to facilitate the issuance of the stable token. We may use policies that are already in place from, let's say, A&I, but we have the ability to do our own, or perhaps where we could do even a blend where, like where we are now, where we're following A&I's guidance and processes to get positions listed, but now we're taking the reins on where it goes from there. We're going to need to screen and interview applicants to determine their qualifications for a given role. We'll need to perform hiring on an expeditious timeline. We are kind of under the gun here. We know that if 4 or more commissioners were perhaps to hop into an interview, that would create a quorum and require public notice and then record of the meeting. So we would want to limit that. And as a result, we would want to spin up, in certain instances, an evaluation committee that would be formed with the director or their designee, some number of commissioners, but definitely less than 4, and then no more than 3 subject matter advisors if we believe that specific expertise is going to be required for, let's say, interviewing a technical resource. And therefore, hereby, the commission would adopt the hiring policy to ensure a structured, fair, and transparent process for hiring candidates for various roles within the commission. So that's the preamble. And then the rest of the document is 5 different phases of how this would work. And I'm happy to sprinkle in some color from what I've seen on my side since applications have started rolling in as to how we got here. So phase 1 is applicant screening. This is really intended to be a fairly lightweight process that doesn't really need to involve the commission, in which the director will look at the applications, and for those that don't meet the minimum requirements or don't have the qualifications to do the job, those can be taken out of the applicant pool and removed. That's pretty much the long and short of this one. That being said, of course, we would make sure to retain all the applications that we get. I've already started creating those folders on Drive, so you all have access to all the apps that come in. It also allows me to reach out to any of the applicants if in case applications come in that are incomplete. And I will say that just based on the way some of these apps have been coming in through the NeoGov platform, some of them don't have resumes attached. People have said they've submitted them, but they have not. So this will give me the very formal bandwidth to reach out and say, hey, this didn't show up for X, Y, Z reason. I just want to see it, and we'll go from there. And then we would kind of make the determination, and if we so choose to, we get to let applicants know that we're going to pass on their application, and then we would move on to the next session. So in the next section, there'll be preliminary interviews. This could be myself or the executive director's designee, or perhaps a small group, doesn't need to be a working group, that would do interviews with potential candidates that we believe, at least on paper, meet the criteria and qualifications that we're looking for. Then this would be a discussion to confirm that they do meet those qualifications, and they also kind of align with our what it is we're trying to accomplish with the Wyoming Stable Token and the commission. And then we would create a subset of qualified candidates out of that pool, and then that would go into the evaluation committee interviews. This is where the executive director would form the evaluation committee. I have here in 2A with no fewer than 3 resources and no more than 7 resources. Again, that's all up for discussion. Would create a rubric that would allow us to essentially analyze and rate the candidates as we deem fit based on their experience in the interviews. We'd have a series of questions to be asked, and we would look to do interviews with no more than 3 qualified candidates, because again, we don't want to create this pipeline where we're interviewing nonstop day in, day out. So we'll need to kind of stay focused on that. Yep, and I think where we end out with the evaluation committee interviews is that the evaluation committee would make a determination, a recommendation to the executive director to proceed with, and then the executive director would kind of take the next step. Now, phase 4 is referred to as optional commission interview. So the thought here is, whereas when I came on board, everything went through the commission because there was no director or other resources yet. If we were to hypothetically have 2 qualified resources for 4 different roles, so that's already 8 people that the commission had to interview, and each of those interviews was an hour, I think that's a lot of time for the commission to be together in an executive session, and would be probably difficult to coordinate. So that's why we've gone to the evaluation committee as kind of the primary version of this. That being said, the commission may select that they want to interview a specific candidate because it may be of a certain import to the success of the project. Perhaps the chief risk and compliance officer fits that role. So the commission could choose to do the interview itself. And then as part of that might happen before, after, or in lieu of the evaluation committee interview. And then the commission would be able to either make a motion to offer any given applicant, start negotiating employment with them, or could also punt that determination to the director. They have the choice to do that, and it's left fairly open here. And then in this last section, section 5, Roman numeral 5, the applicant selection, this states just how in these different phases, whether it's coming through the evaluation committee or the commission, how the determination would work for the director to determine the optimal candidate for the role. That may be taking the recommendation of the evaluation committee or the commission. It might be choosing a different candidate based on the director's understanding or their view on things. But that's kind of the binary choice there. And then there's always the third option, which is if the director deems that there's no qualified candidate, we can restart the process with a different series of criteria, whether that's roles and responsibilities, or that's the intangibles like budget or benefit or salary or benefits or things like that. We can go back to the drawing board on it. But that's the gist. And I know Commissioner Meyer already does have a couple of comments that I have in front of me. We can go through those, but I'm also happy to answer any questions kind of just generally on the document before we get into specific edits that may require a motion to start doing strike through.
All right, does anyone have, before we get into actual markup, does anybody have questions on the overall policy or the overall conceptual process? Commissioner.
Just a quick question on the optional commission interview. I guess what would the process be for the commission to request that interview, and how would that happen?
So through the chair, Commissioner Wallace, I think just if anyone in the commission wanted to kind of make that determination, it'd be hard to make the determination about a determination within a commission meeting. But I just generally think it would be a situation in which it would be added to the agenda of an existing meeting for an executive session, or a special meeting could be called that would be focused on the recruitment and the interviewing and potential recruitment of a given resource. And that is called out here in, still learning my own numbering here. Roman numeral 4, section 2, subsection C. Talk about special meeting or an executive session of the commission.
Any other general questions about the policy? All right, Treasurer, I think your proposed changes are pretty clean. And my understanding is they just give a little bit of wiggle room. I'm gonna have you walk through them, but my interpretation is it just gives us a little bit of flexibility. For example, say we only have 2 really good candidates we want to interview. Anthony doesn't have to choose a third one just to meet the policy if there's no one. But yeah, go ahead and if you want to walk through your proposed
So on the
changes.
first pages in the whereas there, the blue language is what's currently in there that would be deleted, and insert the red language, which essentially says may be formed by a group consisting of the director, and that should be actually the director or their designee. That didn't get in there. I apologize, miscommunication on that. And preferably 1 to 3 commissioners and 1 to 3 subject matter advisors. And I thought that we needed to give a little bit of guidelines there because the discretion was so broad that that I thought it needed just a little bit of guidance on that. And again, that the no more of, that could be 0. And I think it's important to at least, I think, acknowledge that if you can have at least 1 commissioner and 1 subject matter advisor, we'd probably have a preferable outcome. Then Madam Chairman, on page 2, preliminary interviews, section 2B. Again, that goes directly to your observation that this would be preferably no more than 3 candidates. And it essentially says that here, if you don't have 3 candidates, or it says no fewer than 3 candidates, you can actually the process can continue to move forward. The next one, Madam Chairman, is in section 3. This is the evaluation committee interviews. It does, again, gives the wiggle room that says preferably no fewer than 3 and resources and no more than 7. Again, that gets to the point where I don't believe we're going to have a problem with get no fewer than 3, but there may be some instances where that actually was the case. And the same thing with interviews with qualified candidates, preferably no more than 3 candidates. There may be a situation where you actually have 4 candidates that are just totally, there's just no differentiation between number 3 and 4, and so, or between 1 and 4, and so you put them all in there just because you really can't make that decision. And needs a little more oversight. So don't have anything on the other ones. There was something that came up that isn't in this at all, and we were looking at, and our COO brought this up, Norm, is that in the area of if something could be FOIA'd and how much protection we actually have for these folks as far as either applicants or qualified candidates. And because we don't have agency status specifically, we weren't sure whether or not the regular HR rules were applied here in the matter of confidentiality of records and what exactly was something that was confidential. This is just our first cut on it to bring that confidentiality question into the hiring policy. So at least the applicants and the qualified candidates would have some cover. Very well be after the AG looks at this, they may decide that needs to either be broadened, or they may come to a conclusion that instrumentalities have that same protection of confidentiality in HR and hiring matters. And but I want to make sure that we had it in here, so at least there was some cover for people not being FOIA'd into that in the processes that normal that should occur have some protection until we find out whether or not the status is of an instrumentality compared to an agency. So what that language says, and I did get it to Joel and to the governor, that all information derived from this hiring process concerning applicants and qualified candidates shall be considered confidential. So that at least lets people know that they shouldn't be searching for them. Anyway, we figured that they shouldn't be, and maybe we wouldn't even get any FOIA request.
Treasurer, I think that's a good thought. So the overarching question is are the documents and individuals and their information applying? Is that confidential? And I think that's a legal question. I don't know if it's an easy answer or not, and that may need an executive session to answer. Or if it's a very simple answer, I'm happy to have Devin talk about that now. The one thing I would say, Treasurer, while I don't dislike your suggested motion, if they're not confidential and we're still a government, I don't think we can just pass a policy saying they're confidential. I think they're either confidential or they're not. And I think putting a policy in place saying they're not doesn't change that.
Yeah, I understand that policies aren't rules and regulations, and I think that we're probably have to do a little bit of research on the business council and find out whether they do that by policy or whether they consider themselves being underneath the protection of the standard confidentialities of all employee records. We couldn't find anything in the statutes, but we only had
5 minutes.
5 minutes this morning, and so we just wanted to put something in the policy that was there, and to draw attention to that it needs to be looked at. And I think that and the problem with saying as provided by applicable law, if you don't have any law that actually applies to an instrumentality in this situation, you don't have any coverage whatsoever. So it might be something that we could do in rule, but again, if we don't have statutory authority to have the rules, then you're outside of the scope of any intended statute. So we should bring it up. I think this brings it up to where the blockchain committee, can look at it. LSO staff, AG can look at it, see whether or not it should apply. And it may be that we'll have some new legal status on instrumentalities in this regard, and then we can mirror that language in a policy. But I think for now, I think that at least the assertion that there's that confidentiality that every other employee has in any other job interview exists in this circumstance.
So, Mr. Kinney, is that a question best taken offline, or do you have a magical, easy answer for us? And either response is fine, obviously.
So, Commissioners, Madam Chairman, Treasurer, I think the basic answer would be one of two things. I think most likely the Public Records Act would apply to the agency the same to the Stable Token Commission the way it applies to any other state agency. I actually represent Business Council, and to the best of my knowledge, whenever they receive a public records request, they treat it the same as any other agency treats it. There is and you're probably aware of this, but there is in the Public Records Act a specific, there's a list of, may deny things, but there's actually a section that's, shall deny things you cannot release. And one of those is, in the shall deny section, is personnel files, except files available to duly elected appointed officials who supervise the work of the person. This specifically includes applications, performance ratings, scholastic achievement data shall be available only to the person in interest. On the other hand, employment contracts, working agreements, other documents setting forth the term and condition of employment are not considered part of the personnel file and shall be available. So applications specifically excluded, you cannot release them except to the person who made the application. If they requested them, you would release them to that person, but nobody else. If the Public Records Act, the reason I'd say that it's not just necessarily straightforward, I think the answer is probably just that it applies, in which case, to the extent that that what I read there in the statute prohibits it. If we're talking about applications, a person can ask for them and can ask for whatever they want, but we can't give them to them because it's a shall deny. If the Public Records Act did not apply, let's say that we were to determine that because of instrumentality, Public Records Act doesn't apply, in that instance, I think all your records would be, I mean, nobody could make a request for them. The only reason a person can make a public records request is because the Public Records Act applies. If the Public Records Act doesn't apply, then everything is not necessarily confidential per se, but it's not, there's no mandate to release it except for the Public Records Act. So if the fact that you're an instrumentality means the Public Records Act doesn't apply, then your records are protected because no one can make a request for them. I don't think that's the case. I think the Public Records Act most likely does apply. But even in that case, they're still protected because, at least to the extent they meet that definition there in the statute. I mean, to the extent we're talking about like their contract, no, if somebody requested that, we would have to hand those over. But if they met like that personnel file definition, then it would be fine. The other hand, I don't have any, hang-ups or anything by putting this in the policy. I mean, that, just like some agencies sign NDA agreements with folks, and those always say in there that, this only applies to the extent the Public Records Act, because we can't waive the Public Records Act through a contract, but, which means that an NDA is essentially meaningless because all we're saying is we'll uphold the Public Records Act. Putting it in the policy doesn't change the fact that it's in the statute, but does it possibly make it so it's more visible to folks who are reading the policy? Sure. And to the extent it's helpful for that, then I don't see any issue with doing it.
Madam Chairman, we, I guess the default position that it's not accessible, we felt that maybe if the act wasn't there, default position was that it would be accessible. And so that's why we wanted to put some protection there. So, I guess I can defer to the AG's office on that. But yeah, our first read was because in the Public Records Act, it specifically said agencies and did not say instrumentality. So I guess we wouldn't comply. I mean, I wouldn't have to comply to anything if that's in true. The default is you don't have to.
Yeah, I mean, if you wanted more definitive on that, I would certainly want to take that and do more research on that specific subject. But the best of my knowledge, prior to the Public Records Act existing, there was no obligation to give folks records if they were to request it. That's why they created the Public Records Act.
Okay.
So if you were to say that it doesn't apply because it is instrumentality, then I think that
Yeah,
default
it's-
rule would apply and that you don't have to give anybody any records.
Yeah, it's not on the list.
Yeah.
So.
Thank you. Well, we
Interesting
learn something
discussion,
new
I
every
guess,
day.
we may discuss. So I guess it does no harm, but there again, I wanted to bring it up because that was concerns that we had in our office because instrumentalities was on the public records list. So.
Madam Chair.
Commissioner?
Thank you, Madam Chair. As someone not within the government, what I look at this as is a comfort clause, which to me, if I were applying for a position, I would like to have this clause in there just to know that in all cases, we will try to keep the information confidential. So I would like to see that in there if we want to qualify it by saying as discussed in the Public Records Act or something like that. I'm fine with that too. But I think having this simple statement in there will help provide comfort to someone that is looking to apply.
Yeah, that makes sense.
Treasurer, in your 5 minutes, did you happen to find a place to put it in the policy or a?
I would just start it in basically probably do a new one, just make that statement and renumber. So 1's 2, 2's 3's, 3's 4, and just put a new one and just say that coming out of the gun.
So very first under Roman numeral 1, and then that'll be the first statement.
Yeah.
Under there, that would be your proposal.
And so the thing would be confidentiality, you know, and then you just say that statement under there with one. And then you got a one sentence section.
Gotcha.
Madam Chair?
Commissioner Pope.
One other question is whether we want to include another part to that basically says we're an equal opportunity employer, whatever else that language normally has in it. I know in every job posting I have to do, I have to put that statement in.
My initial thought is that is all done through NeoGov where they're posted and where this is an internal policy for us. I'm inclined to not start including some things and not all things, if that makes sense. Does that?
Madam Chairman, you are correct that a lot of that context about equal opportunity employment, family medical leave, all of those things are included in NeoGov.
Right.
That being said, to be specific, we are in parts of this talking about a bit of a hybrid approach, right? So whereas the commission may use policies and procedures developed by the Office of Administrative Information for recruitment or may exercise its statutory authority to recruit employees as it sees fit, I would think that we're probably fine for where we are because we have 4 positions already listed. If we were going to go completely independent from A&I's processes, then we would want to just lift and shift the language from what we
On
have
everything.
and to put it onto our own recruitment documents wherever those live. If we were hypothetically going to do all of our recruitment off of NeoGov and do it on our own website and leverage, policy groups in the blockchain space to host jobs, job applications, job offerings there, we would want to make sure whatever we created would probably include that language. I don't know if that needs to be part of the policy. That could be the application, not the hiring process itself, which I'm things we're trying to focus on here.
Madam Chair?
Commissioner?
Then I would withdraw that recommendation.
So far, and for folks online, the treasurer has made a suite of changes. I think there's 4 total. 1, 2, 3.
Right. On basically adding preferable.
And then adding the information about confidentiality. We can certainly go through those changes one by one, but if everyone is sort of okay with them, I think we could do those as a group. Does anyone else have any thoughts or proposed changes they may want to make in the form of amendment?
Madam Chair, I completely agree with all these. I guess, just thinking about it though, my only question is on the number for the evaluation committee, do we want to include preferably, or do we want to require at least 1 commissioner? And then that would apply to Roman numeral number 3, number 2A as well. So I guess in my mind, if we're saying preferably, I guess theoretically, that could be just the director.
Commissioner, I think that's a great question, and here's my knee-jerk reaction to have some thought to it. The organization is so small right now, meaning there he is, that we sort of know everything that's going on, and we know when we will want to be involved. So if Anthony tries to go out, this Saturday and hire these 4 positions without any input, that's probably not going to work out very well for anyone. And we will know that, and I think
Including Anthony.
can assert our involvement. However, if he hires a part-time admin person to put together board packets, and at that point he has, for example, 3 other people on board, that's certainly not how other agencies work. So could one of us be involved? Absolutely. Would it be necessary for potential future more administrative or part-time positions? I think maybe that's where that flexibility might be welcome.
Yeah, and I thought of at least 1 but no more than 3, that language, and I thought, well, that gets me back into the thing. what happens when we don't have maybe a subject matter advisor because they're all in the bidding process or something. So, yeah, so I thought, well, let's just give some guidance there and see how it shakes out. If we have problems, then we can go more language that's actually even stronger guidelines.
No, that makes sense to me, so I would withdraw that.
From online, Governor or Joel, any thoughts, or are we feeling okay with the policy as proposed and tweaked by the good treasurer?
Madam Chair, I think those are, make sense to me, and I appreciated the conversation. It is a delicate place that we are going, so I appreciate it.
Madam Chair, I have no additional comments and also like the direction we're going.
Well, Madam Chairman, with that, I would move the proposed amendments to the hiring policy.
Is there a second?
I'll second.
You have 12 seconds, pick one. Okay, any further discussions? And this is to add the treasurer's amendments to the policies. So that is the proposed language on page 1. And then there's also a preferably added on page 2, section 2, number 2, and 2 preferablys added section, or page 3, section 3. And then his final amendment that is being currently moved is all information derived from this hiring process concerning applicants and qualified candidates shall be considered confidential. And that would appear as a new Roman numeral 1 on page 2, and everything else would be renumbered. Is that clear? Did I
Yes.
get those right,
You got that clear?
Anthony?
Madam Chairman, just to make sure I understand correctly, for the addition of all information derived statement, that would be a new Roman numeral 1 at the top of the whole thing, we'll write everything down. That would be titled confidentiality?
Yes.
Okay, got that. And then regarding, not to be pedantic, but the wording on page 1 that is in red. So this would be, we would strike out what's in blue. So we would read, whereas at the discretion of the director or the commission, an evaluation committee may be formed of a group, including the director or the designee.
Sorry, I forgot.
May be formed by a group, may be formed of a, so
And-
it's, whereas at the discretion of the director or the commission, an evaluation committee may be formed, and that may should be a lowercase m, may be formed by a group consisting of the director or the designee, and preferably 1 to 3 commissioners. I would need to do to be specific, that'd be 1 parenthetical, the number 1, 2, 3, the word parenthetical, number 3, commissioners, and preferably 1 to 3 subject matter advisors.
Yeah, and from my perspective, not being an English major, I don't know whether we need a semicolon where is there a comma or a colon, but to clarify it, if you want to add another preferably in there, then we know that preferably is on both of them. And I think we'd probably just drop down to a comma, because you need that Oxford comma before an and, so both of them apply.
And I'm sure both the mover and multiple seconders, implicit in that motion was the ability to add grammatical corrections.
Yeah.
And Treasurer, I'm very glad to know you're an Oxford comma guy, as I am an Oxford comma girl.
I got that in watching a Supreme Court case being argued in front of the Wyoming Supreme Court here, and that question about an Oxford comma came up, and that most states implied the Oxford comma exists, but in Wyoming, it's got to be there, or anything behind the and doesn't go with the preceding subject, so.
Okay, any further discussion on the treasurer's proposed amendments? All right,
As amended, yeah.
all those in favor say aye.
Aye.
Opposed? Okay, then I think we need to move approval of the entire hiring policy as amended.
So moved.
Is there a second?
Second.
Any final discussion? Good job, Director. This, like I said, I think, although not required, this really gives us a good handbook for a starting point. And if we got teeny tiny things wrong, we can tweak in the future.
Thank you, Madam Chairman. I would just note one more thing. We have on here recommended motions from the director. I would say if there was a motion to authorize the director to fill out any forms or other things that other agencies need, that way I can move more expeditiously on this. I will leave that to the commission, but I would recommend that.
I would
Thank you.
move that recommendation, Madam Chairman.
Is the seconder okay with that amended motion? So that's just authorizing the executive director to complete any forms to do the hiring.
Yes.
Okay, all those in favor?
Aye.
Aye.
Opposed? Okay, great. Motion carries. Good job.
Thank you, Madam Chairman, and thank you all for the feedback. I know this one's kind of coming in again, a little hot off the presses, so I appreciate the quick triage and we get this done because this will greatly expedite the work we're doing around recruiting and getting some more hands involved here. So with that done, if there's no other questions on the recruitment side of things, I would segue us over to the back of the agenda and we would move into procurement now, which should move a little bit faster. Provided we don't do any wordsmithing. I do think there's been much more opportunity to review the procurement rules, but I'll just quickly walk through what you have in front of you, and we'll take it one dock at a time. So we've talked in the past about the differentials between regular rulemaking and emergency rulemaking. I provided the commissioners with documents from the Secretary of State's office, from the Attorney General's office. Those of you on Notion already have access to the rulemaking portal where I've linked all of those. And this is just one kind of quick at-a-glance document that I found that I thought might be helpful just to kind of review the regular rulemaking process versus the emergency rulemaking process in one place. So again, to just quickly level set, we do expect for the procurement rules specifically, which we have in front of us today, that we would parallel path these simultaneously through the emergency rulemaking process to get them enacted quickly, promulgated quickly, and then start a pre-qualification and vendor selection process through request for proposal. And of course, in the background, we will be going through the regular rulemaking process that does include the public comment period and will take longer, but will be more robust, and that will be our kind of long-tailed view of this. But now you've got your cheat sheet for both emergency rulemaking and regular rulemaking in one spot. And again, if you need more context, we have all those documents nicely custodied in Notion. The second thing I have in front of you is a cover sheet for the procurement rulemaking, which I'll review in a second. And then the third thing is the actual drafted procurement rules that we would put forth. And I'll talk about those within the context of the cover sheet. So going into the cover sheet, again, the action for us is to approve the draft procurement rules and then pursue regular and emergency rulemaking in parallel. We again have the statutory authority to do this. WS 40-31-105B gives the commission the ability to adopt rules and regulations as necessary to administer the act and to ensure compliance with all applicable state and federal law. And then WS 40-31-110, that is from the Stable Token Act amendments that were passed during the budget session this year. That is what allows us to do our own procurement by competitive bidding processes. So that's all quoted here in the cover sheet to kind of establish that we've got the authority to do what we're looking to do here. Flipping over to page 2, you'll see my analysis. And this is where we'll kind of start talking about the procurement rules by reference. So what we did, just to kind of reiterate some of this, is to create the procurement rules that are drafted here in front of you today. We leveraged what was done, the most recently promulgated set of procurement rules from an agency, which was the State Construction Department, which passed theirs in 2021. Mr. Kenny was part of that process and was very helpful in helping us get these together as well. So my analysis here is predominantly focused on describing our procurement rules through how they differ from State Construction Department. So to quickly run through these, because again, I've circulated these with the commissioners, a couple of structural things around the procurement rules we're putting forth. One is, again, similar to the recruitment side, we are a much flatter organization. Whereas the State Construction Department has multiple different procuring agencies that roll up to their own director, that roll up to the State Construction Department and their own director. It's me and you. So it's a little flatter. We've worked to preserve some of the checks and balances here, but you'll see the language is different from place to place around things like emergency rulemaking. Sorry, not emergency rulemaking, emergency situations, emergency contracting. Second big change here is the State Construction Department in their rules split out their chapters into procuring professional services and then procuring everything else through competitive bidding. That's because the State Construction Department has professional services formally defined in their statute. We do not. So we have a bit of a broader spectrum here. And what I've done is the second chapter of our rules is focused on a request for proposal process. The State Construction Department's rules did include that within competitive bidding. We've popped that out because we do expect that to be the methodology by which we do predominantly most of our vendor engagements. And it also allowed us to include pre-qualifications for RFPs rather than just segueing it into through bidding. So that's another change. We've changed some of the definitions. So I wanted to make sure I called out, we updated the definitions of bidder and proposer, which were intended for singular entities, to also include consortia, because we do expect that bids or proposals may come through as a collective of different organizations that we want to treat as one party, but just based on how their tech stacks may work, it may be multiple, end users or end parties that we're looking at as one cohesive whole. And we'll also just redefine services and materials to make them more general and capture anything really that we're looking to do, because we are going to be procuring everything from technology development, which is quite ephemeral. We're going to be working with finance teams. We're going to be perhaps at some point in time, we need to get physical infrastructure. So there could be some, a little bit odd now, but might be a use case in the future where we need actual, Bitcoin mine equipment or nodes to run our own version of a blockchain network to make sure that we had our own version of the ledger. That would be hardware that would need to fit into this kind of fairly robust definition here. So that's included. Moving on to number 4, entity domicile. So the State Construction Department has a statutory responsibility to engage resident firms. We do not, but I also wanted to make sure we reflected and respected what we received from the legislature during the budget sessions. When we received our budget, that did come with the language that says the commission must endeavor to contract with Wyoming domiciled entities. So we don't have a requirement to contract with Wyoming domiciled entities. I've added it as part of our evaluation criteria to make sure that that is a consideration for the commission when we go through this process. Moving on to number 5, evaluation committees. Quickly, this is very similar to what we have in the recruitment or the hiring policy that we just went through. Again, we need to be aware of forming a quorum as the commission. There may be some discussions or vendor interviews or vendor presentations we want to be public, but we also may need to move expeditiously. Schedules might be tight, so we may want to avail ourselves of evaluation committees as a way to score and rank the different vendor proposals or bids that we receive and use that as the way to get ourselves to contracting. Turning over to page 3, thresholds. Financial thresholds that determine which type of procurement we do were lowered from what the State Construction Department has. They use $50,000. We brought that down to 15, which is in line with the Office of Administration and Information. The thought here is while our development and our procurement may still be expensive, it's not going to be building a building expensive. And as a result, we should have thresholds that reflect that. Emergency situations, those typically were defined to be things that may endanger physical health or well-being. We've expanded the definition here to include various pieces around the stable token itself, its underlying physical infrastructure, or its underlying reserves, which are all things that, if threatened, which is possible, may need immediate triage by the director or the commission to resolve those issues as quickly as possible. Eighth item here, this is a quick one. The State Construction Department has a chapter called Alternative Design and Constructive Delivery Methods, which essentially allows them to subcontract building and management out to a different party. We're not going to be doing that in any kind of specificity. So we've removed that. And we've also removed terminology or requirements around bid securities or performance and payment bonds, which may be standard in buildings and those kind of contracts, but it's not something that I've seen in tech build out. So that's come out. And then again, recommended motions here are to approve the procurement rules as drafted or as amended, then to authorize the executive director to pursue regular and emergency rulemaking for the procurement rules, inclusive of, again, formatting or grammatical updates, any changes that would be immaterial to a reasonable person, or completion of any forms required by the different agencies. I want to be specific on that last one because the formal rulemaking is a process that crosses the Attorney General's office, the Secretary of State, the Governor's office, the Management Council, and I don't want to be stuck in a position where we need to wait for the next monthly meeting to complete a form or approve a form that is potentially trivial, but just something that would require the commission if that authority was not granted to the executive director. So that's a lot to throw at you. I'll pause there for any questions or comments on the cover sheet for the procurement rulemaking.
Yeah, Madam Chairman, and Anthony, this might be for council. The question I would have is, I know we always have to comply with Wyoming law, and if there's a dispute, it's the venue's always Wyoming. I don't know whether those are in rules. And then the other thing that the AG has is that we always have sovereign immunity in all these cases that we deal with on our I guess, managers and some of our vendors. So I'm wondering if that's present in here or whether that's always handled through the contract negotiations at a later date and whether that's required in these circumstances.
Madam Chairman, Treasurer, so those provisions, I mean, I don't think anything would be inherently wrong with necessarily putting them in here, but those are covered in our standard templates for contracts.
Okay.
And so as I understand it, and it's one of the contracts unit attorneys could get up here and speak to it even better, but there's statutes that require that contracts go through the AG's office, and those are sort of non-negotiable terms. They always have them in there. With minor exceptions, there may be instances where we're hiring somebody overseas, for example, and we may not be able to get them to do venue in Wyoming. That may just not be possible. But sovereign immunity and venue are things that they won't negotiate on. That they're sort of like, if you're not willing to sign a contract that says it, then we're not going to do business with you. That's just sort of what it is. So as long as we're using the AG contract templates, which we should be, because I think you're required to go through our office anyway, then those will be in there.
Yeah, I'm just wondering whether it would save us some time with people that necessarily won't follow the AG's template to notify them, so they necessarily self-select out of the process. I don't know whether that would be a good thing or a bad thing, because maybe there's somebody out there that we're not gonna, that the sovereign immunity is a drop dead one. The venue is not quite as drop dead, but it normally is, because we don't want to be under the laws of France or Grand Cayman or whoever. Yeah. So.
If I may respond to that quickly. So through the chair, Commissioner Meyer, if you look at Chapter 4, Section 2, Contract Negotiation Execution, this is where we do specify that we'll be using the Attorney General's templates. We don't need to necessarily add any language in here. This is.
They know where to go to find it. They know what.
Right, and that would go back to a different section where we talk about the bidding process or the RFP process, where we would, when we do the bid advertisement or the analysis process on the procurement side, we would let these prospective vendors know, here's how this is going to happen should you be the chosen one, right? Because if those groups self-select out, then that's less work for us to do and less back and forth if our number one pick can't, for whatever reason, have a contract that has a venue of Wyoming, right? And I will say there's been a few vendors, potential vendors that I've spoken to who've referred to that as kind of due diligence, right? They're also interested in learning all of this before they go down that road. So whether that gets, I could see that very easily being something that we put as a, let's call, appendix to the pre-qualification surveys that go out. Here's what they need to know about you, but here's what we need from you, and here's how this would operate should we go forward. And we could be as transparent about that from day one. I don't think we make any changes between now and then that would be needed to be incorporated in there.
And I would just add that I don't know that this is required, but I've seen a lot of agencies, or at least the state construction department, they will often attach the contract template when they put it out there. So that's one possible way of just putting it out there and saying, I mean, of course, it's still subject to negotiation, because, I mean, there'll be particulars. I mean, whichever entity you select, obviously, you have to put them in there and their price and fees and stuff like that. But it gives people a heads up that this is what the contract looks like. This is the format we use. We're not using your format. Our format looks like this, and this are the provisions that are in there. So folks can see it and read it in advance. So hopefully by the time you get to selecting them, they are aware, and you know, they're more likely, like you said, to have self-selected out if they're not willing to sign something on our templates.
Director, I do have one question. Your proposed motion is to authorize you to pursue regular and emergency rulemaking of the procurement rules, but do we not, and I know this is just getting into the weeds, but my understanding is we actually need to go ahead and approve the emergency rules and authorize the regular rulemaking process. Is that accurate? Go ahead and say these are, because I don't think you can pursue the emergency rulemaking process on your own. Is that accurate?
Madam Chairman, I think first we would look to approve the actual rules themselves, and then from there, I mean, I don't know if it matters if it's the commission sending a packet to the governor or myself sending the packet to the governor, but what I do know is there are a number of different forms that need to be included in that packet: certification, notice to proceed, justification for why we are pursuing emergency rulemaking, and these are all things that I don't, you know, if it's easier for me to move forward with those kind of independently, I mean, the rules will be the bulk of it. Everything else is kind of just process around it, and that's what I'm trying to expedite here. And if that's an incorrect statement, please, someone feel free to correct me. It does seem like the governor has his hand up, so he probably knows better than I do.
Governor, go ahead.
Thank you, Madam Chair. Yeah, you know, the rules that come from an emergency, as you and I and the treasurer know, we do authorize as a board emergency rules for state loan and investment board, and then we also authorize rulemaking. And it does appear to me that, you know, there are some agencies which don't have a board that occasionally will, you know, the Attorney General's office, for example, when there is a change in a medication that is now considered illegal, they can issue those independently. I think just as to form, it probably makes sense to authorize emergency rules and authorize rulemaking.
Good, thank you. Okay, so what is the commission's preference as far as going through these? We have had them for quite a while, and the updated version for a few days with Anthony noting the changes. Any major concerns or any section in particular, or any amendments anyone thinks may need to be made?
Oh, Madam Chairman, my questions were asked and answered, and I feel confident that that those issues will be addressed at the appropriate time in the process.
And Mr. Kinney, I think you've been invaluable to set us on a straight path with something that's already been done. And I'm confident we may need future minor tweaks, but Joel or Commissioner Revelle or Governor, any concerns with the actual text of the rules? And again, just saying out loud, we would be passing emergency rules if we figure that we've, a word needs changed or a process needs tweaked, that then can be activated in the regular rules.
Madam Auditor, I believe that's correct.
All good here, thank you.
All right, if
Well,
there's,
Madam Chairman, if there's no further discussion, I would move the emergency rules as provided. And I guess those would be the same rules that were the regular rules, but I don't think we have two copies. But I guess the record will reflect that the emergency rules are the rules that are in our packet.
so would your motion also include authorizing the regular rulemaking?
I think we'll do two separate
Oh,
motions.
okay, great. Okay, so authorizing the emergency rules. Is there a second?
Second.
Any further discussion? Okay, all those in favor?
Aye.
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 Opposed?
Madam Chairman, and now I'll authorize the process on regular rules to that we adopt those going forward.
Is there support for the treasurer's motion?
Point of clarification, if possible. Does that include all of the language that the director recommended in item 2?
This is, I think, what this one.
Okay. Yes, in both circumstances, Madam Chairman.
Then I second.
And just for the record, that motion is to authorize the regular rulemaking process, and which includes allowing the director to fill out any required paperwork, make all
Correct spelling,
submissions
yeah,
required, and
changes,
any
yeah.
grammatical or spelling errors.
Yeah, immaterial, yep. A, B, and C, and all the above.
I'm sorry, Commissioner Pope, did you second that, or were you just asking the question?
I did second it.
Oh, okay, super. Any further discussion on the procurement rules?
Madam Chair?
Go ahead.
Quick question, Director. When you were creating, and this goes to kind of what I may have a suggestion on this, I may not. When you were going through the process of creating positions, did any of the agencies you dealt with insist on certain changes to those, either the descriptions or titles of those individuals? And was that a process that was in any way drawn out?
Through the chair, Commissioner Pope, I think, well, the brief answer is when we went through our getting these positions, there was some back and forth dialogue around certain titles. I'm just not entirely sure where that fits into the rulemaking side of things. I might be missing something.
Madam Chair?
Go for it.
Okay, so as part of C, we are giving you the ability to complete any forms required by agencies involved in rulemaking. And if those agencies insist on material changes to these rules, do we want oversight or approval on those changes if they make if they are a significant deviation from or amendment to the procurement rules? Do we want to have to come back and discuss those before agreeing to those changes, before allowing the director to agree to those changes?
it'll all come back and we'll all have a second bite of the apple after, you know, the public comment period and all of those things and any changes that's suggested. And then we'll go through the process, you know, in a manner of course of making sure that, you know, whether it's from public comment, if these come in, if the director, you know, wants it or not, you know, we'll go through all of it and we'll either agree with the director's recommendation or we might look at public comment and twink it. It's all up for grabs, so before they actually are rules.
Madam Chair.
Go ahead.
Very good. Please chalk that up to my inexperience in the government sphere. So that removes my only question and discussion item on it.
And the governor can actually veto rules if he so chooses, if they're not within the intent of the statute. Yeah.
All right, any further discussion? Okay, all those in favor?
Aye.
Aye.
Opposed? Yay, haven't we done a good job, Director?
Thank you, Madam Chairman. I think we have. And with that being said, the last note I have on procurement is that this is going to unlock our ability to then go forth with pre-qualification criteria and requests for proposals as well. This is something that we've kind of had kicking around. We've approached it and then, you know, come back for whatever reason that we kind of just redirected our attention somewhere. But with this done, we now have the ability to go and create the pre-qualification surveys that will allow us to identify the type of vendors or consortium of vendors that will really give Wyoming the product that it needs, and recognize this is a very high risk, high reward project. So we need to work with those who are qualified, who have experience either on the finance side, the technical side, the audit side, whatever it happens to be. We'll find the right partners for this, and I look forward to working with the commission and the working groups on those criteria.
I'd say kind of stay away from saying it's high risk, high reward, saying that it's a project in which we will prevail in mitigating any risk and reap the high rewards. There you go.
Through the chair and Commissioner Meyer, what I was looking for was the state's reputation is on the line, but I haven't had my second cup of coffee yet today.
Okay.
So
Yeah,
that's
yeah,
typically
yeah.
how you phrase that. And,
Yeah, we changed our IPS on investment, saying that, you know, that we take high risk and put it toward the back and actually say we mitigate it. So, yeah, there you go.
Wise.
Just yeah. Little bit.
I prefer boring and stable with moderate returns.
Absolutely. Yeah, well, with exceptional returns from very qualified.
Okay, it looks like our next item is public comment. Is there anyone in the room that would like to provide public comment? Hearing none, do we have anyone online to provide public comment? Thank you, Brian. Okay, hearing none, I will close public comment and we will go on to upcoming meeting and events.
Thank you, Madam Chairman. I'll keep this very quick. We do have the next meeting of the Select Committee on Blockchain, Financial Technology, and Digital Innovation on Monday and Tuesday of next week, taking place in Sheridan. I'm not sure if anyone intends to be there in person. I will not. I will be dialing in on Tuesday morning, the 2nd. Stable token is up at 8:35 a.m. Mountain Time to provide an update, which will be very brief. We just gave this 6-month update in their last meeting about 6 weeks ago. So this will be focused on our recruitment of new hires and procurement and where we're going from here. And that'll be a very quick one from my side. And then our next meeting of the Stable Token Commission is scheduled for July 18th, right here, same time, same place, in the Wyoming Capitol Auditorium at 9 a.m. Mountain Time. I'll quickly say, I think that's a bit of a quicker turnaround. It's already the end of June, so it's about 3 and change weeks. Plus we have the 4th of July. So we're gonna, you know, my goal is to be very focused on the pre-qualification piece and of course, you know, kicking off the rulemaking, which will then have a longer tail along the way. So we'll get that started as soon as possible. And then as the days track by, we'll get the prequals done, subcommittees will be helping with that, and we'll go from there.
Thank you. Any concerns about upcoming meeting dates, other events? Governor, Commissioner Revelle, any closing thoughts? Wisdom?
None.
Okay.
I just do have one thought to share with the director and perhaps to provoke some conversation amongst the commission. In my opinion, I think we're doing an excellent job of moving forward with rulemaking and sort of the technical and operations focused bits of the work that we need to do here. I don't think there's any question of the market opportunity that exists here, and it's growing, and the potential revenue opportunity for the state that could emerge from this. But in my view, a very significant question that we really haven't addressed yet is the market adoption and the marketing strategies that will need to be in place to ensure that the good work that we're doing to build this stable token doesn't go unheard and does have a fair opportunity, a fair shake at market adoption. And so I think that this was the right sequence of ways to do things, and this was how I would expect a public body like this commission to proceed. But at some point, I think there needs to be an increased emphasis on the marketing strategy and strategies more broadly to drive adoption of the stable token. And doing so in advance of the launch would, I think, be well advised.
Thank you, Commissioner. I think those are wise words, and I think it's interesting. We've really had to not slow down, but I mean to sort of step back and fit this in the governmental box. And so to your point, we're starting to see a place where we are looking to some of those more exciting things as opposed to procedure and paperwork and whatnot. So I appreciate that.
Madam Chair,
Go ahead, Governor.
to respond, and I believe it is, and Director Apollo, you can correct me if I'm wrong. I think Commissioner Revelle's comments are well taken and well placed. I do perceive the work we've done today actually is a formative and formidable step to sort of accelerate the process. And so I do appreciate the comments, but I think we needed to do these things, but now there's a lot of things coming our way. So my comments.
Yeah, Madam Chairman, and I just say, Anthony, I think you've moved in governmental parlance closer to the speed of business, the speed of government. And Governor, thank you for greasing some of the wheels on that regard, and the communication avenues that you've been able to provide to Anthony and the help from the different agencies and stuff to get the Stable Token Commission's efforts moving in I guess a reasonable speed for the government process, probably more than reasonable. Thank you.
Madam Chair,
Commissioner Polk.
I'd like to echo Commissioner Revelle's comments on the marketing and say that going forward, now that we have fit into this box that Commissioner Racines has talked about and Chairman Racines, there are going to be a number of parallel tracks that Director Apollo is going to have to be putting into place and monitoring and pushing forward. And we've already got 3 or 4 of them defined within the subcommittee structure, and I think that the marketing needs to be one of those as well. And all of these need to converge at release. And it is a task that is unenviable. And like the governor, I believe that we've moved this forward quite a bit now that we have the structure in place to do so. So thank you, Director Apollo. I appreciate that. And I totally agree that that does need to be one of those parallel tracks that we need to follow.
Yeah, Madam Chairman, I think we're going to see a lot of the marketing actually start to occur in the sandbox with our vendors as they're beta testing all of these things that we're doing. And if we can get the right people playing in the sandbox, as soon as this thing is ready to roll, the implementation will be rather quickly. So, yeah, we've got a lot of proof of concept and making sure that everything is safe and secure and functional. But once that work is done in the sandbox atmosphere, so you're not in the open market, it should be fairly quick after that. And it's just getting all those people to play nicely and do everything right, you know, in that environment. And then that would allow quite a little bit of, I think, quick implementation. That's my hope anyway.
Great. I think that's a point well taken. While the marketing, it may be one of the later steps, it shouldn't be an afterthought. So, all right, with that, any other closing comments? If not, I'd entertain a motion to adjourn.
Move to adjourn.
Second?
Second.
All those in favor, say aye.
Aye.
All right,
Aye.
thanks, everybody. We are adjourned.